All right, it's 12:02. Thanks for joining us. We're going to go ahead and get started. My name is Kathryn Hoffman, and I'm the Executive Director of the Minnesota Center for Environmental Advocacy. And you're joining us today for our Leveraging the Law webinar. Thanks so much. I will be serving as the moderator for today's panel and also contributing some things from MCEA's perspective. So we're here today to talk about the rule of law and how it's been attacked in some ways and weakened in some ways by this administration, but also how it's being used in smart, effective, sometimes innovative ways to protect our democracy and to block tactics of this administration that are designed to expand federal or executive powers. And there are a lot of media reports about what's happening. I think sometimes it's hard to make sense of, even as a lawyer, let alone as a non-lawyer, which many of you are. We hear that lots of bad news for the most part about what the Supreme Court is doing. We hear that the administration is sometimes defying court orders, especially in the immigration context. And we also hear that the administration is losing a lot at the district court level. So how do you make sense of all of this? That's what we're going to try to help you with here today. And what does it mean for the rule of law here in the United States? All of our panelists that are joining me work for organizations that rely on a functioning rule of law in order to advance our missions and our work, whether that's protecting immigrant rights, advancing gender justice, safeguarding our environment or climate, or strengthening consumer protections and protecting Minnesotans. And MCA is hosting this conversation today because we see risks not only to immigrants and immigration law, but also to other areas of justice, including law enforcement, environmental law, gender justice. So these are injustices that affect all of us and should matter to all of us. So we wanted to have a more expansive conversation. Our usual webinar format is about an hour. And we're expanding this one, you may have noticed when you signed up, to about 1:15. And we're doing that because this is a big conversation, and we really want to give our panelists the time to dig into it. And so let's do that. And here's where we're going to start. I'm going to introduce each of our panelists, ask them to share their title, their work, what they do, and then one word to describe their current feelings about the future of the rule of law in the United States. So, Jenny, I'm going to start with you. Why don't you kick us off?
Thanks, Kathryn. I appreciate the invitation to join you today and to my fellow panelists. I'm Jenny Stohl Powell, and I am the Executive Director of the Immigrant Law Center in Minnesota. We are a nonprofit organization celebrating 30 years this year of providing legal services to low-income immigrants and refugees. We serve the entire state of Minnesota with offices in southern Minnesota, Worthington, Austin, our main office in St. Paul, and we have an office in Moorhead, Minnesota. In addition, we serve refugees and asylees, people granted asylum in North Dakota, and have an office in Fargo. We provide a full range of immigration legal services, from helping people become U.S. citizens, working with DACA holders, dreamers, to renew their status and work permits, helping survivors of domestic violence and violent crime gain immigration status, and working with immigrants in removal proceedings, particularly individuals who are detained and vulnerable, unable to represent themselves in immigration court. That, in a nutshell, is who we are. And as far as my one-word answer, I think that's a hard one. I would just say at this point, frustrated would be my response.
That's fair. Thanks, Jenny. And thank you for joining us today. Okay, next I'm going to go to Joseph Richie. Joe, why don't you go ahead?
Thanks, Kathryn. I am a special counsel at the Minnesota Office of the Attorney General, and I work in the Attorney General's Rule of Law division. And we do work focused on what we call federal accountability. And so those are lawsuits that Minnesota brings against the federal government to protect Minnesota or Minnesotans from illegal actions by the federal government. And we also defend lawsuits that the federal government brings against Minnesota. And we do a lot of other work too, but I think it all kind of revolves around keeping the federal government in check and doing what we can do to make sure it stays within the law. Since January 20th of last year, our division has filed 52 lawsuits against the federal government, and we're defending 3 lawsuits that the United States has filed against us. And we've been successful in over 90% of those cases where we have some sort of decision, either where we've sought preliminary relief or where courts have issued final judgments. And a lot of them are still going, so those wouldn't be included in that number. But we are having significant success. Just a few examples of the kinds of things that we've been doing. We sued to challenge President Trump's executive order purporting to end birthright citizenship. This is the doctrine we've had in place since the Civil War, where any person born in the United States is a citizen, and the president has purported to end that for certain children of immigrants. We've challenged orders regarding gender-affirming care, of which there have been many. We've challenged funding freezes and grant terminations. Those include things like FEMA funds to prepare Minnesota for emergencies, Department of Transportation funds to repair our highways, SNAP funding, which used to be called food stamps, to feed needy people in Minnesota, child care funding, which obviously has been in the news. Some of these are instances where the government just turned off the funds and said Minnesota's not going to receive money anymore. Some are situations where it wanted us to agree that we would go along with its priorities in order to get money to do things like cooperate with immigration enforcement or oppose DEI policies. Regardless of what they've asked us to do, though, we've been successful in suing. We challenged President Trump's tariffs, which the Supreme Court struck down 2 weeks ago. We've defended lawsuits trying to terminate immigration non-cooperation policies here. A lawsuit that the United States brought to challenge our policies of allowing affordable college to students regardless of immigration status. And more recently, we brought a lawsuit to end the immigration enforcement surge in Minnesota and unlawful behavior by ICE and CBP. So those are just a few of the things that we've been working on since last January.
Great, thanks, Joe. So what's your word? The future of the rule of law.
Sorry, my word. I'm going with salvageable, which is meant to be optimistic. We can protect and save the rule of law, but it requires work on everybody's behalf, and that's always been the case. I think that's the story of the United States: is people have had to fight to expand civil rights throughout our history, and we're at a critical moment now where we need to keep up that fight.
That's great. Thanks so much, Joe. All right, I'm going to turn now to Jess from Gender Justice. Jess, you want to introduce yourself?
Sure. I'm Jess Braverman. I'm the legal director at Gender Justice in St. Paul, Minnesota. We do a lot of impact litigation, meaning cases intended to move the law forward on issue areas mostly around sex discrimination, which we view really broadly. So we do abortion rights, access to contraception, trans rights, and other LGBT rights. We, for a long time, have been using state laws, state constitutions, and state courts to get outcomes for our clients. We're not in the most civil rights friendly federal circuit court, the Eighth Circuit. And so we realize that, for a lot of things we need for our clients that they really like material things they really need to thrive. We are often better off going into state court and using state law and state values and state constitutions to get those outcomes. We do also bring cases in North Dakota, and so we sued over their gender affirming care ban in North Dakota, and that case is in front of the North Dakota Supreme Court. We're briefing that. And so we do a lot of kind of plugging in civil rights gaps with state laws. But, that's not to say I don't really like living in a country where your fundamental civil rights varies based on what state you live in. So it's not that that's how I think things should be. It's more of a pragmatic approach. Um, and After the ice surge in Minneapolis, in Minnesota, we put together a reporting form to capture instances of sex discrimination or sexual harassment or other similar issues where ICE targets people related to their sex. And um, the word I will say like trepidatious because it has a lot of syllables and makes me sound like an adult attorney. So I don't have a better answer than that. I have like a lot of different feelings about it and it's hard to capture in one word. So I'll picture the smartest sounding word.
That's good. I mean, when in doubt,
Yeah.
especially as a lawyer, you should
Yeah.
go smartest sounding word. So I
Yeah.
support. All right, thanks, Jess. And thanks to all of you for being here. And I'm sure I speak for all of our participants as well when I say thanks for your work. I want to take a moment to introduce myself and MCEA here. So a lot of folks that have signed on today are probably MCEA supporters. You probably know a lot about us. We are a 51-year-old environmental law nonprofit. And we were founded on the premise that the industry hires good lawyers and that the environment should also have good lawyers representing it. And that was, some time ago. And the organization has changed in many ways. Notably, we've grown quite a bit since then. But the basic premise has not changed. We are the lawyers for the environment here in Minnesota. And that means we work across a wide range of environmental issues here in Minnesota. It could be sulfide mining or pipelines or clean energy or agricultural pollution. Recently, a lot on data centers. So we kind of plug in where partner organizations and communities need us on environmental issues. Um, and I'll talk more later about why our work depends on the rule of law, but of course, we use primarily state statutory law and some federal law in order to protect clean air, clean water, and our climate here in Minnesota. So we're primarily going to state courts, although we do occasionally go to federal court as well. We did recently, for example, go to federal court against the Trump administration because they were rolling back some mercury protections. There was federal law, but applied primarily to taconite mines, which are mostly in Minnesota. And that there's a lawsuit now called MCEA versus Trump. And it alleges that these mercury regulations should be enforced. And this one seems like a no-brainer to us. Mercury is harmful to pregnant women, harmful to children, has a demonstrable impact on children's development, as an example. My word on the rule of law is uncertain, because it does feel like we're at this moment where things could go either way. I am not pessimistic about it necessarily, but I think Joe made a really good point that our democracy has always depended on the willingness of participants to enforce it and to enact our social contracts that stem out of our Constitution, and that we're seeing some people who aren't willing to uphold that, and we're seeing a lot of people that are. And how that all ends, I don't know more than anybody else, but I do see the work of folks like the people on this webinar as being really critical to helping influence a better outcome at this uncertain moment. All right, so let's get into our questions a little bit. I want to set a little bit of context here. MCEA hosted a similar webinar as this one on the rule of law earlier in President Trump's second term. And at that time, we were talking about this sort of more threatening posture from the federal administration towards our legal system. So there were some threats to judges, for example, especially district court judges who did not rule the way that the administration wanted. And we're now seeing perhaps even more overt attacks, especially in the immigration sector. So Joe, I'm going to start with you, representing the AG's office. What have you seen happen to the rule of law here in Minnesota over this time? And I want to ask you to also provide for us a definition of the term rule of law. Lawyers throw this term around a lot, so do journalists these days. I think it'd be helpful to hear a definition from you.
Well, thank you for giving me an extremely difficult philosophical question that you could probably have an entire law course on, but I will try. The old adage about the rule of law, and it's dated at this point, is that it means a government of law, not men. But what does that mean? I think the basic principles underlying it, in my view, are that everyone is treated equally, that decisions are made by a set of agreed upon predetermined rules, and that they're not made by the whims of any one person or group, and are independent from those sorts of influences. That's kind of, I think, a rough sketch that's in my own mind of what it means to live in a system of the rule of law. And we've never fully achieved that, and we probably never could. But I think that until recently, it's been a really difficult concept for American lawyers to grasp, because there's been so much consensus about the rule of law as an aspiration that I think you can't really appreciate what it really means until it starts to slip away. It's kind of like a fish who doesn't realize he's in the ocean until he gets yanked out of it. And I think we see it slipping away, and it's increasingly, I don't think we even agree that those principles that I was talking about, or similar principles, are even an ideal that we all hold. So a few examples: the Supreme Court held that the president is basically above the criminal laws and immune from prosecutions. The government is routinely ignoring habeas orders, which I think are a critical cornerstone of the rule of law. Our immigration enforcement officers, or the agency, I should say, has concluded that it's not subject to the Fourth Amendment, which restricts unreasonable searches and seizures. The president is using his position to enrich himself, and those who want pardons or favors can donate to his ballroom, or give him gifts, or make lavish payments to settle frivolous legal claims. We're seeing racial profiling. We're seeing arrests of people with lawful status by immigration enforcement. And I think the thing that maybe is most telling is that we see disfavored people and also disfavored states being targeted for retribution. And so we've seen indictments of people who Trump has personal feuds with. And we see, I think most clearly, Minnesota has been targeted these past several months because of political retribution reasons. And in a functioning rule of law, none of that would be happening. And not only is it happening, it seems that substantial portions of our political leaders are not bothered by it. And I think that is maybe the most scary aspect of it all. But I think what the rule of law is and its importance is really come into focus since that consensus has started to slip.
Yeah, thanks, Joe. That's super helpful. And this targeting of Minnesota, Jenny, I want to turn to you, because this has come out in a way that's incredibly central to your work, that using the law and enforcing and protecting immigrant rights. So what have you learned in your organization about the strengths and vulnerabilities of our legal system during the ICE surge and occupation?
Sure. Thanks, Kathryn. I'm going to share a couple of examples, just, what we've seen, what we've experienced, and some which I think you're familiar with. Last year, early on in this administration, we did a lot of Know Your Rights trainings with our partners, and we distributed these red cards. Kind of looks a little blurry. And I'm hoping that many of you have seen these. Can't see your faces to know if you're nodding, but I hope you have. But we worked, to get information out to communities so that people did know what their rights are if they interacted with ICE and other federal enforcement officials. And I think it really worked early on. We heard stories of people, knowing that they didn't have to open their door and let ICE in. And so they didn't. We had, folks even call us while ICE was at their door, and, they knew they didn't have to open their door. So that's how we would train them. But in January, one of the things that we saw during the surge here is that federal agents started breaking down people's doors to arrest and detain individuals. So while we had trained that this was their rights, we later learned that ICE didn't see it that way. They leaked a memo that was from last May, earlier this year, where the acting director of ICE said agents can forcibly enter homes without a judicial warrant. So here we are training people that you need a judicial warrant, but they weren't respecting that and saying, we don't need one. We can do this with an administrative warrant, but that's a constitutional violation. So, but disregarded. So that's one example of, this is what the law says, this is what actually happened in practice. I think the other thing I would share, and I tell people this a lot, I've been doing this work for about 30 years as an immigration attorney, and this is the hardest that I think it's ever been for our clients and our client community. And one of the things to know about immigration law is that it's federal law, and a lot of our practice is administrative. We prepare applications for clients to file with an administrative agency. But one of the things we've really seen, I think, is the failure of Congress to act and change the law, because what has happened in the last year is changes through policy, through executive orders, through changes to guidance, proposed rules, presidential proclamations. So since January 20th of 2025, there have been 652 changes done through policy that impact immigration. For example, the Department of Homeland Security has terminated temporary protected status for 14 of the 18 countries where it's been in place. That is protection for individuals from countries going through civil war, through environmental crisis, that allows them to be in the United States and to work here with permission. Some of those countries' status has been extended through litigation, but in other cases, the administration has terminated parole programs, such as the Cuban, Haitian, Venezuelan, Nicaraguan parole program that allowed people to enter legally in an organized way. And so while some of those program terminations are under litigation, what's essentially happened is we've taken individuals who had lawful status, but converted them to someone with unlawful status by terminating these programs. So it really helps demonstrate that challenge of, the administrative rules and the changes that they've been able to make through that process versus having the law, the statutes changed by Congress, because there really hasn't been any change in the law. It's just been in the way that it's been interpreted and implemented, and the guidance that's changed over this past year.
I had not heard that number before, Jenny. That is wild. I mean, just aside from the obvious inhumanity of these changes, but also the tremendous burden on your staff to keep up with all of that.
Yeah. We did put in the chat the tracking website that shares that. It's a project, it's called the Immigration Policy Tracking Project. It's a project of a professor working with Stanford and Yale law students and immigration law experts. So it's a great source, and they update the number depending on the date. So 652 was as of March 2nd. It's possible it's changed since then, but you have to continuously check.
Yeah. Yeah. Well, and this, I think non-lawyers may not fully grasp the significance. I mean, you're describing ICE officers acting with impunity and violating court orders, violating rights, as your organization has understood them and described them to people, and how much that can impact not only your work, but the broader work. Um, and, I see that. I see it also potentially affecting environmental rights. I mean, our work is through Minnesota statutes and also federal statutes. Many environmental laws are actually citizen suits, essentially. So the idea is they're suits by people in order to enforce the law. And you can do it to fill a gap where the federal government is, or the state government is not enforcing that law. And that depends, the effectiveness depends on the social contract of people being able to assert those rights, that they're not being intimidated, that they're not being threatened to deter them from asserting their rights, that their First Amendment rights to speak up are being honored. And those norms just aren't as stable as they were 18 months ago. And that's why for us as an organization, we have joined community and statewide efforts such as the general strike in January and invited our partner organizations to do the same. We've talked to our donors about why this matters to our work, and invited many of our partner groups to join the general strike as well. And some of them took that invitation. Jess, I want to turn to you now and ask, how do these threats to rule of law affect your work at Gender Justice?
I think I think this is, you can say this is something new and unprecedented, and I think that's fair to say. But I do tend to look at trends, and I think like one trend that this just kind of puts into overdrive that affects our work is this like desire by courts, especially appellate courts, like higher level courts, like the US Supreme Court, to want to read good faith into the things the government does. And it's completely unfounded. Like there's no basis in reality for doing so. And so it's this kind of fairy tale land where courts don't want to look at motivations. And it takes a lot to actually get them to go there. And so I can give some examples. Like a long time ago, there was a case in front of the US Supreme Court about pretext stops. Like, what if a police officer stopped someone who technically broke, like, the police, to set the stage for this, right? Like, police can pull you over and find a reason to have pulled you over after the fact, right? Like, there's so many regulations about cars. It could be like something hanging off your windshield, a crack in the windshield that you didn't. I've seen this. I've had this case before that you didn't put on your blinker exactly 100 feet before you're making the turn, right? Like it's a sun shower and you don't have your things on. They can just figure it out after they stop you, and we know they do this. And so the question is like, if the police pull someone over and like technically fine, there's some violation as we all have whenever we get in the car. But you want to say like, okay, but this is racist. Like you've never stopped a white person for this. You've never, like the court basically said, like, we're not going to deal with pretext stops. Like we're not going to go in and try to psychoanalyze the mind of the police officer who pulled you over. And it gets to the point of like, what if you don't have to psychoanalyze the officer to know why he did it? Like, what if he just tells you why he did it? And the courts are like, they still don't want to deal with it. And I promise this is all related to what we're talking about today. It's just backdrop, right? And so when the government passes bills, there's different levels of review that a court subjects those laws to, right? And the lowest level of review is called rational basis review. It is like basically a rubber stamp for things the legislature does. So they pass a law, they say like, all cars have to be red in Minnesota, and the court says like, sure, why not? They have some reason for it. We'll accept anything. That's great. But then you have other laws that affect like people in a really fundamental material way, and that same standard applies to them. So it's like we're going to take away gender affirming care from trans youth, right? And the court applies rational basis review, and it's the same analysis, right? Like, yeah, sure, like we're just, I'm sure the government has some reason for doing that. Now, what do you do when you walk into the halls of government, right? Like you sit through a Capitol hearing and they're outright saying horrible things about trans kids and their parents, right? Like just the most god-awful things that you only like would otherwise read like on the internet. Like it's not how normal people communicate with one another, but they're doing it so that they can like clip themselves saying it and put it up on the internet and gain all sorts of like political points with their base for having been like just terrible human beings. Um, you know, what is the court supposed to do when they're faced with that much clear evidence of animus? And courts still do not want to deal with it. And I think this is one of the biggest problems with rule of law, where President Trump or, you know, the current administration, right, can outright say like, and I'm sorry to repeat the terrible things he says, he said, you know, say terrible things about like Somali people, and somehow we still want to read good faith into the surge in Minnesota, right? Courts want to. And I think what we're seeing is like the district court, like the lowest level court, the first one who's actually like the judge who's actually sitting there having to deal with these problems, talk to these people, see what's going on. They're getting fed up because they have to see it, right? They have to sit with it. They're not so distanced from it. But as the issue creeps across the courts and gets to like the highest court in the land, they're so distanced from the human problem. They don't want to deal with all the evidence we have of animus, and they're just letting things go, right? And I think this is one of the biggest threats to rule of law, and it impacts our work to a huge degree because the bills that we're challenging, the laws that we're challenging, are passed in an environment that is so hostile to like children, right? Like so hostile to their parents, so hostile to LGBTQ people, so hostile to people who need contraception and abortion. You know, lawmakers outright say they want to impose their religion and their religious beliefs on constituents like that. I'm not reading into it. Like this is the actual dialogue that goes on, and courts are still letting these things go. And I think this isn't new. I think with the current administration, it's just so much more clear that it's happening because he'll just outright tweet horrific things about human beings. And the courts are still like, I don't know if there's animus, right? And I think like the problem has just been magnified. And so it affects the work we do because we work with people who they're not politicized, like they're not political people, they're just human beings, but their lives have been politicized to a completely untenable and unsustainable degree. And when you go to court and say, like, look, I have an entire record of the people who passed these laws saying like they hate these people, courts want to close their eyes to it and still give good faith. And so I think like that is a huge threat to rule of law. And I think that's what's on just full display for everybody right now. But there's lots of communities who've known this for a long time. It's just like the degree of it and the blatant parading of it is more than what we're used to, I would say.
That's a really interesting point, Jess, and I can absolutely see why that would be a through line in your work that would be much more noticeable in other places now. I saw both Joe and Jenny nodding, and so I want to pause there for a minute because I think this is something that is a really important point. And we do see efforts by lawyers to bring evidence of, for example, Trump's public statements into cases to show animus. And I'm wondering if that's something that's come up in either of your work or in your offices. And if so, you know, if you have seen that have an impact with the courts. Are judges listening?
Oh, I can go. Yeah, this is definitely happening, and I think how Jess said it was just perfect. The we have tried to use particularly social media statements in a lot of the work that we do because people remain very unfiltered in social media, and we've tried to use that in our cases. We have used that in our cases. You know, for example, when the federal government shut off SNAP benefits nationwide back in November, they were very explicit about trying to score partisan political advantage by that, and that they thought that people would blame the Democrats and that it would disproportionately hurt Democrats. And they were saying these things. And we put that into the record, before the judge that our case was in front of. And there was also a private organization that had a very similar case, and they did the same thing. And in our case, the judge kind of got to where we needed her to go by avoiding wading into those issues, because I think there is such a deep reluctance to do so that I think is kind of dates to this idea that we all used to maybe work in good faith. It was probably never true, but that it's so ingrained in us. The other case, though, the judge did look at that stuff and say, yeah, it's clear that this is a political partisan thing. Same thing happened with our case concerning the surge. There were scores of statements about why they were here, and they were here because the president tweeted, or Truth Social or whatever it's called, that the day of retaliation and retribution is coming to Minnesota. That's unlawful. You can't retaliate against a state by sending 3,000 armed goons into it. But then we had statements from Kristi Noem immediately calling Alex Preddy and Renee Good domestic terrorists. And we've tried to use all that, but I think there's just a deep institutional reluctance of the judiciary to really grapple with people's true motivations. And I think, like Jess very eloquently said too, struggling to assume the best even when there's no plausible way where you could see good or legitimate intentions.
Yeah. Okay. So, something else that we see are a lot of these cases are attracting a lot of other parties, organizations, and not necessarily parties to the case, but also organizations or businesses that support the cases. So, for example, in the case of in the ICE surge, we've had the general strike. We've had a lot of businesses in Minnesota. Maybe not the biggest ones as much, but a lot of companies speak out. And I'm wondering, like for you, Jenny, in your work, like what's the impact for your work, or what does it mean to your team that there's been a lot of public outcry over the ICE surge and the treatment of immigrants?
I would say that it's one of the things that, helps us keep going and doing this work at a really challenging time. Just the support of the community, organizations. We received things in the mail like artwork or things that people have made, just really wanting us to know how much they support the immigrant and refugee community here in Minnesota during this challenging time. And if it's okay, I'm going to talk about another kind of case example because I think, well, it's important because it's an ongoing case here. And it has to do with how we're treating refugees. Joe already referenced what happened in December, the pretext of we're going after Somalis, we're targeting fraud. But it's gone broader than that, and an attack on refugees. Because Minnesota is one of the places that has welcomed refugees traditionally, because we have a strong refugee resettlement community here. But in early January, on the 9th, the Department of Homeland Security announced a new operation called Operation Paris, which means Operation Post-Admission Refugee Re-Verification and Integrity Strengthening. And what they've said it is a sweeping initiative to re-examine thousands of refugee cases through new background checks and intensive verification of refugee claims. And that their initial focus was on the 5,600 refugees here in Minnesota who have not yet received their green card, their lawful permanent residence. which is something that you apply for after you've been here for 1 year. And just to remind folks, refugees are people that have a well-founded fear of persecution for one of the basis of race, religion, nationality, political opinion, or membership in a particular social group. And they are approved to enter the United States as refugees. So all the processing happens outside the United States, the security vetting, the application, the medical exam, all of that happens before they even arrive here. And so through this new operation, they decided, well, we're going to arrest and detain refugees. So in mid-January, one of our clients was arrested at her home, detained here at the Federal Whipple building, and very quickly moved out of state. We saw a lot of these folks that were arrested move to Texas. She was sent to a contract facility in Houston and said that she needed to be revetted under this new operation. And she already had her application pending for her green card. So they held a phone interview. Thankfully, our legal assistant who handled that case, who's accredited to handle immigration cases, answered the call because we didn't have any advance notice of the interview. Normally we would prepare clients, we'd have advance notice. She was questioned about her application. Later was approved and released. But talk about re-traumatizing refugees by arresting them, detaining them, sending them out of state. So there was a lawsuit filed towards the end of January by some national groups, but the local group, the Advocates for Human Rights, was one of the organizational plaintiffs in that case. And they requested a temporary restraining order to stop the department from arresting and detaining refugees who had not gotten their green cards and requested class certification. The temporary restraining order was issued at the end of January to prevent the arrest and detention. And one of our clients was arrested the very next day, thankfully only for a few hours and released, but definitely a violation of that restraining order. And they did hold a hearing on the preliminary injunction in that case on February 27th. And the judge really walks through, Judge Thunheim really walks through our, I mean, just the history of the protection of refugees, the Refugee Act, saying, you know, in the Refugee Act, this nation extended a helping hand to those escaping persecution. We made a simple process, pass the vetting, follow the law, and you will be given a new beginning, a new chance in safety. And goes on to say that the government's proposed new interpretation of arresting unadjusted refugees, folks that haven't gotten their green card, upends the commitment that we made to them without clear authorization from Congress and rests on constitutionally precarious grounds. So I think the order really underscores, you know, the language that the government's used and their arguments for doing this to, you know, don't comply with the federal law and how we've treated and processed refugee cases, how they've gone through security, and the revetting is still happening, but those interviews are still taking place. So we're waiting to see if all those folks are going to be revetted through basically 4-hour interviews taking place at immigration. So.
And well, and I mean, what a statement from Judge Thunheim as an effort to extend principles of justice that were clearly stated in the law. Are you seeing compliance with the restraining order or no?
At this point, we're not seeing refugees being arrested and detained, but we'll see if that holds. I mean, the other thing is it only protects people here in Minnesota. What's going to happen to refugees living in other states as they roll this out across the country. There has been a national lawsuit filed as well, but that was just filed recently. And in the meantime, everyone is receiving, interviews to, go in for this additional vetting that they've already been through before they came into the United States.
Okay. Thanks for sharing that story. Joe, I want to go back to you and just ask about, some of the suits that the AG's office have filed have received a lot of parties weighing in, a lot of, and many in support of what the AG's office is doing as well. And I'm wondering if you could just comment on that and how that's affected your work.
Yeah, I think one of the great things about our work is that we do have, even before the surge, a lot of support. In particular, we work with attorneys general offices around the country to bring a lot of suits as coalitions. And that has really been able to expand our resources and let us attack a lot of big problems in an organized fashion. In particular, since the surge began, we've had an outpouring of support, and I'm sure you all have, from around the country, from national nonprofits, from law firms, from some leading law professors who want to help us or want to do work that is complementary to what we're doing. One of the problems, and it's a problem that all of us face, is we have issues of standing in the type of work that we want to do, where as the Attorney General's office, we can bring lawsuits on behalf of Minnesota. And so we can do a lot that ILCM or Gender Justice can't do because of that, but they can bring lawsuits that we can't bring on behalf of individuals, which is something that we are less able to do. So it really does take, I think, government and nonprofit groups, organizational groups working in tandem and complementary to achieve a lot of the same goals that we have. In particular, in our ICE case, one way that groups that are not directly involved in a case can still participate is through what's called an amicus brief, which is friend of the court. And so a group that feels like it has a particular stake in a dispute can submit an amicus brief explaining, kind of what their unique view is and how it affects them and what they want the court to do. And we got a lot of those in our ICE case. In particular, though, locally, we got one from a lot of our local bar associations, which are, professional organizations for lawyers, usually organized around a geographic or kind of unifying principle. And I made a list because I wouldn't be able to remember them all. The Minnesota State Bar Association, the Hennepin County Bar Association, the Ramsey County Bar Association, Minnesota Women Lawyers, Minnesota Asian Pacific American Bar Association, the Minnesota Association of Black Lawyers, the Minnesota Hispanic Bar Association, and the Somali American Bar Association all submitted an amicus brief in support of our preliminary injunction motion in our ICE case, which I think is one more example of this unique coming together of our community that we all saw, are still seeing because the surge is still happening during this. Neighbors looking out for neighbors, in this case, maybe lawyers looking out for lawyers. No, that would be a good way to put it. But our legal community really coming together around this issue.
Yeah, I read that brief, and I sort of joked to the team that I don't know that I've ever been proud to be a member of the Bar Association before. The Bar Association's fine; it's a thing you do, because you're a lawyer. But reading that brief, the Bar Association could have kept their head down and said, this is too political. We don't want to weigh in. But they decided to make a different choice. And I really appreciated that. And I also think it's a sign of the times of how significant the threat is to the rule of law, that the Bar Association did feel empowered or obligated to step in this moment and provide an opinion on behalf of tens of thousands of lawyers of those various associations. So I want to shift to, we got about 10 minutes before we get to the Q&A, and I want to shift to what's been working or what strategies we see are successful. I'm going to shift our order a little bit, and I'm going to actually start with Jess. And Jess, I'm wondering what do you see as things we need to do to strengthen rule of law in the future? What tactics are working right now? Take us to maybe a little bit more hopeful place.
Yeah, so we've had a ton of success litigating cases under the state constitution in state court. It's something that doesn't get talked about nearly enough in law school. I had exactly 0 classes on state constitutions, but it's the thing I probably use the most in my actual litigation. And that's been true for my whole career when I was a public defender, when when I do impact litigation. State constitutions are really fun because sorry, you could tell I'm like a nerd. State constitutions are fun, but they are. There's 50 of them. They're all different. They all have like an interesting history about how they came about, and they all have unique provisions that other state constitutions don't have. And they have things that are missing that you would just like assume would be there and aren't. And I really like litigating under them. And the best part about using them when you litigate is like you are then litigating like Minnesota's values, right? Like you're saying like, who are we as a state? How do we treat people as a state? Because there's stuff that, there's the supremacy clause of the US Constitution, which means like federal law is supreme, and it can even be when there's a conflict, when there's an actual conflict between a state and a federal law. That can even be true over state constitutions. But if there is no conflict, we get to decide. And so right now we are trying to get an equal rights amendment on the ballot here in Minnesota. And I think that would just be a really fantastic addition to our state's constitution. It's expansive and inclusive. So it includes race, it includes national origin, it includes sex, gender identity. It includes pregnancy outcomes and the decision about like whether and when to remain pregnant. So yes, it would protect abortion rights, access to contraception. And it calls for what's called disparate impact, meaning it calls for the government to really take a careful look about when they're passing a law that's going to harm like people based on race, that's going to harm people based on national origin. It's something we don't currently have expressly in our Constitution, and we should. And the thing people don't understand is, when I go into the legislature and I talk about the Equal Rights Amendment, lawmakers always say like, oh, this is going to stop me from passing this law or that law. And that's not really how constitutional law works or is supposed to work. What it requires is the legislature to actually have a reason they're passing the law, to articulate that reason, for that reason to be sound and not just based on like conspiracy theories or animus. And then the court tests that reason to make sure that it's legitimate. That's how constitutional rights work. There's typically not a lot of constitutional rights that are like just blanket, like you cannot do this, right? It often like ends up in front of a court that does some sort of balancing test. And so what the Equal Rights Amendment in the Minnesota Constitution would do would be exactly that, right? It would be the solution to the animus problem I was talking about, because you can't just then go into the legislature and say, I'm doing this because I want the entire state to live according to my religious beliefs. You couldn't just go into the legislature, which people do say. I'm not just making this up, right? You can't just go into the legislature and say, like, I want to ban transgender girls from girls' sports because the idea of it makes me uncomfortable, right? Like, you have to actually articulate why you're doing what you're doing and not just be like slam dunking to get a video up on your social media. Sorry, I'm older than I look. I don't really use social media, so that's why I'm like slam dunking. I don't know what terminology the kids are using, right? But you can't just be like in the legislature and your whole goal is just to appeal to your base, and you're in doing that, you're doing terrible things to people, because the court's going to review it and they're going to make sure that you weren't doing that and that you have a real legitimate reason that can be backed up by actual people who know what they're talking about. And so I think that's really important. And so we are hoping to get an Equal Rights Amendment through. If we don't do it this year, we'll try again next year, but we think it's important enough to keep trying because it sets that value in Minnesota of like, look, people are tweeting, people are saying terrible things, but like not here. Here, if we're going to harm people, we better know damn well why we're doing it. And we better have a really good reason. And we better be causing as little harm as possible to achieve our goals. And so that's one thing people can do to kind of get involved is support the Equal Rights Amendment, learn more about it, and see how you feel about it and see what you want to do with it. But that is something we are looking at and that's I just wanted to provide a little legal information about what it would do, and everyone can decide for themselves, is this for me or not?
Yeah, great. Thanks for sharing that, Jess. All right, what about you, Jenny? What do you find is working or giving you some hope in this work?
First, I'm going to say thank you to Jess. That was a good reminder of what constitutional law looked like in law school. Good refresher. What I would say is working right now is what's happening in the Federal District Court of Minnesota. To get clients out of detention, immigration attorneys are needing to file habeas corpus petitions challenging the unlawful detention of clients, which is done in federal court. I believe since early January, about 1,000 habeas petitions have been filed here in Minnesota. I also attended a federal bar admission in January for our legal director, and I will say that immigration attorneys are getting sworn in high numbers. Like the ceremonies for swearing in are full. So I think seeing the federal court really step in and hold government attorneys accountable is something that gives me hope. There was just a contempt hearing held on Tuesday, which was part of a case where the government was ordered to return property of detained immigrants because one of the things that happens, their property, all their paperwork, their keys to their car, maybe their apartment, their employee badges, everything that they have with them, is taken when they're detained. And in many cases, they're being released without their property, and sometimes they're being released in Texas across the country without any of their documents. How do you arrange travel? You don't have an identity document. So in this case, as a result of some of the habeas petitions that were filed, demanding the return of property and the government not fully complying, the judge held a contempt hearing for the government attorney this week. So you can read about it in the Star Tribune because it is in the news. But that's one of the things that gives me hope, and something that we're learning as well, because we haven't always practiced in federal court, but now we are.
Yeah. Okay, thanks. And what about you, Joe? I mean, your office has been sort of the tip of the spear on this issue of rule and law. You mentioned that your high success rate in terms of these lawsuits against the Trump administration. What do you see that's been most effective in your work?
Our litigation strategy, and I think those of similarly situated, state government organizations or other or nonprofits, it's largely working. And I need to say, I don't want to diminish the horrors that lots of people are experiencing, because we can't stop all of it. That's never going to be something that we're going to be able to do through litigation alone. But we're winning our lawsuits, and they tried to turn off, I'll go back to SNAP. These people rely on that to feed their families, hundreds of thousands of Minnesotans, and they tried to turn it off. And except for a little blip of a disruption in November, those essential benefits have kept flowing. People are getting their TANF payments, which they tried to shut off. We've been able to protect birthright citizenship. We've been able to do a lot of things to stem some certainly not all, of the worst impulses of this administration. And you hear a lot about the administration ignoring court orders, and that is happening. And Jenny would know more about it than me because it's happening largely in the immigration context. But they are abiding by a lot of orders as well. And I feel like that can get lost in the news outside of the critically important habeas realm in the immigration realm. And again, I don't want to diminish that. They are largely abiding by the orders that we're getting. And so that I think is more successful than the news might convey. The Supreme Court has been a horrible place to litigate for many years now. And you hear a lot about the rubber stamp that it's been for the Trump administration. And all of that is true. But if you're looking for bright spots, everything that has happened so far, except for one case, has been on what's called the shadow docket, or the emergency docket. It's called different things. But those are kind of quick look decisions that are not with the benefit of full briefing and full argument, where the court really slows down to take its time. They've only had one of those decisions, a merits decision, regarding the Trump administration, and that was 2 weeks ago when they shot down his tariffs. And so it would be naive to say that this shows that the tide is going to be turning on those things, but it's not impossible. And the other thing I just want to mention, and I think I alluded to it earlier, is outside of the legal or the litigation world. I think I'm really heartened by how our communities have rallied and continue to rally these past few months. I think the administration chose a uniquely poor place to make their test case for this kind of immigration surge. And I think they underestimated Minnesotans and the way that we unite together, people in their signal chats and their whistles in observing and recording, and they didn't let up, and they're delivering groceries, and they're doing these things that less cohesive communities might not have had. And they turned this into a deep red stain for the Trump administration. If anybody's looking at the news during this thing, I just saw that Kristi Noem was fired during our webinar here. And I don't know that would have been the outcome had they picked a different place to try this out. And that heartens me as well.
Yeah, I did not see that news, and that's fascinating and interesting. So thanks for sharing that. And I mean, I've also been inspired by the district court judges. You know, Jenny mentioned Judge Thunheim, and there are others. And also, you know, we're going to transition to questions. So this sets up, I think we're getting quite a few questions about the U.S. Attorney's Office and the contempt hearings that have been happening recently, and sort of what do you do when you have an administration or the government that defies the law? And I mean, one of the things you do as a lawyer is you quit. And we've seen that happen in certain circumstances, especially at the U.S. Attorney's Office. And I don't know, I just want to pause here for a minute, because I don't know that non-lawyers understand the ethical duties that lawyers have that are separate from their employment situation. So when a lawyer, you know, takes the bar and signs in, they take an oath. And that oath includes a variety of things. One of them is that they become an officer of the court, and they have a duty of candor to the court. And so what that means is you can't, as a lawyer, knowingly present untrue evidence to a court, for example. And we see this in why, like, prosecutors quit, because they're pressured to bring charges by their employer that they believe are frivolous or have no basis. And that's because it's a violation of their duty to the court. And lawyers also have a duty to their clients to serve them ethically and effectively, which means things like showing up to court prepared when your case has a hearing, which we've also seen to be a problem recently with the U.S. Attorney's Office, because you have attorneys that have way too many cases, or maybe they're being assigned, it's not their specialty of law. And the thing that I am impressed by is how continually we're seeing lawyers abide by those or attempt to abide by those ethical duties, and in some cases step away from this system where they cannot comply with their ethical duties, which is something that makes me kind of proud of our profession. And so I want to open that up to others. I mean, what happens when the government ignores court orders? What should we expect to see, if anything, coming out of some of these district court hearings that have been happening here in Minnesota? How about, no one's sure, huh?
Well, I mean, just
Well,
from
what is it?
reading
Go ahead.
the news, I mean, in the case, the one that was just held on Tuesday, the judge hasn't ruled out imprisonment as a consequence. I mean, I don't know that it will go that far, but it's being threatened for noncompliance.
Yeah. Joe, what does it mean for your office that the U.S. Attorney's Office is running out of personnel?
You know, it's we've seen in a lot of the cases, in the cases that we have here in Minnesota, they're increasingly being staffed by people from Washington and not by local folks from our U.S. Attorney's Office, and that seems to be a problem of staffing. And when we communicate with their office, we've historically had, I think, a good working relationship with them because we're, two different government offices. But just the response times are a lot slower, I think, because they're so overstaffed. It doesn't directly affect us, but one of the things we're seeing now, well, it affects us as Minnesotans, not so much as in our capacity as at the Attorney General's office, is there have been several criminal prosecutions now that the U.S. Attorney's Office has had to drop because they just don't have the people to bring those cases to trial. And so the surge was brought under one of the pretexts, there were many, was that it will make us safer. And now where they have real criminal cases against people who are alleged to have done actual criminal things, not immigrants, they're not able to prosecute them anymore because of this mess that has been made and what's happening in that office. So we see a lot going on there. And I need to add, our judges, I think we should be very proud of them. I think it is even threatening or raising the issue of contempt, I think is something that is difficult for a judge to do. It's just kind of against the things that we believe in, and particularly so against, I think, the federal government lawyers, because they've long enjoyed, they call it this presumption of regularity, that they're working in good faith. And there have been many instances, maybe over the past, where it hasn't been deserved, but it's always been there. And it's eroded to the point now where we get orders like the kinds that we're seeing from Judge Schultz, from Judge Bryan, you really extraordinary orders, saying that they're going to hold them to task for not complying with those orders.
And I just have one small thing to add, which is prosecutors have a separate code of ethics. So we talked about like the ethical requirements of lawyers not to bring a frivolous case, but like, to be clear, as a public defender, I read this section over and over again because I would get very frustrated, but they're not supposed to like bring a lawsuit that they can't support with probable cause, right? Like, it's not just a frivolous lawsuit. Like, if they should be winning more than they're losing, and if they're not, it may be an ethical, like that's not an ethical violation, but what might be underlying what's going on there could be an ethical issue. They're not supposed to make extrajudicial statements. Like, they're not supposed to be making statements outside of court other than just educating the public. And they're supposed to be stopping other people in government from doing that, because they're not supposed to be influencing the trial by, for example, calling people domestic terrorists, right? Like, there's a whole separate code of ethics for prosecutors. And we're seeing that code of ethics just be violated on a daily. The question is, like, I think some prosecutors in the office are there trying to keep it together and have just a crushing caseload because they're understaffed. But it doesn't change there's no like exception in the code of ethics for that. And so I think that the prosecutors who are with the AUSA's office in Minnesota who are left are facing a very serious ethical dilemma that's well beyond what the ethical dilemma civil lawyers normally face of like, I have to zealously like represent my client. I can't make a frivolous case. I can't, I don't want to get sanctioned. Like what prosecutors have a huge responsibility, and it comes with a very direct code of ethics that applies to them. So
Yeah, thanks for that reminder, Jess. That's a really good point. So there's way more questions in the Q&A than we could ever get to, and I'm grateful to the audience for all your questions. I do want to move to a final question for our panel, because there's an opportunity. I mean, this rule of law is a collective effort, right? It's not just about us as advocates or as lawyers. It's not just about the Bar Association. It's much bigger than that. And I want to go to, what can people do? What can the folks in this webinar do to help support the rule of law? I mean, I will start with two ideas. One is do make donations to nonprofits that work in the rule of law. This is an incredibly challenging time to be a nonprofit attorney. You've heard the stories today, and nonprofits need your support. If you are in a position to give charitable donations, this is the year, honestly, to give deep. And we have links to MCEA, to Immigrant Law Center, and to Gender Justice, all in the chat. So please do make those donations. Secondly, we do have an action alert from MCEA related to data centers, which may not sound connected, but it actually is, because data centers are a good example of entities that are coming to Minnesota and subverting public comment and standard environmental review procedures, and we're needing to enforce the law against them. And this is an important part of, I think, local democracy. And so there's an opportunity for you to take action and ask the legislature to act on data centers, so that we're preserving the ability of communities to decide what happens in their community, which is pretty fundamental to the rule of law. And so those are my ideas on what we can do today. I'm wondering, I'm going to go to you, Jenny. What would you suggest for folks here today?
Sure. I did share a link in the chat, 10 things you can do to support immigrants and refugees. So please take a look at that. The other thing I want to say is it's not over in Minnesota. We know that ICE is still here. There's still, according to news sources, there's still about 650 federal agents on the ground in Minnesota this week. The other thing I wanted to do is also just shout out the ACLU Minnesota, because they also are litigating cases to uphold the rule of law. Two of the cases that are of interest to our clients are one about unlawful stops and without warrants, and also arrests based on racial profiling. And the other one is about the arrest and mistreatment of protesters. So those are two of the local cases that you can look for and follow that the ACLU Minnesota is handling. Thanks.
Yeah, great idea. Thanks, Jenny. How about you, Joe? Do you have any suggestions for folks on the call today?
Yeah, I've got a couple. Obviously, I echo contributing what you can, and to MCEA, ILCM, and Gender Justice, all great choices. Another thing people can do is subscribe to good local journalism. We need high quality local journalism. We need people able to do those jobs. It's really important. Advocate for accountability for ICE and DHS. And you can do this at the state and at the federal level. At the federal level, we could see some sort of funds to come to Minnesota to compensate victims and governments and businesses. Everybody's borne the brunt of this in some way. We could see waiving sovereign immunity to allow lawsuits against ICE and CBP officers who violated the law. At the state level, we could also enact legislation to allow lawsuits against any officer, state or federal, who breaks the law, and allow for damages. And I think that would be an important step for accountability. And we could enact legislation to keep immigration enforcement away from places like schools and hospitals and churches and courthouses and places that you should be able to go without fear that you're going to be detained. Sign up for a constitutional observer training if you haven't done that. or sign up to work as an election worker or as a judge. We're all looking anxiously to November, and the more good people that we have looking out for irregularities and protecting people's rights as they go to the polls, the better.
Great ideas. Thanks, Joe. All right, Jess, I'm going to give you the last word.
Well, if you go to genderjustice.us, you can follow our email listserv, and we have, updates about our cases, about legislation. You can see if there's any legislation you support. I used to think, like, I'm not going to write my lawmakers because they don't care what I think. But then I started to meet lawmakers, and I learned that, like, sometimes they only get like 4 emails about a bill. Like, they do read your emails, and those matter. So I think that was really eye-opening for me. Like, I was very like jaded for no reason whatsoever. It turns out that they like do care what you have to say. So yeah, just follow our listserv, and then keep doing all the amazing things people are out there doing. Like, it's at the protesting, exercising First Amendment rights, like, it is working. If you can't make it out to a protest, but you can make it out to, or you could donate, money to a mutual aid group, or, whatever it may be. I do think that the protesting and the mass uprising it's I don't always feel this, like, sometimes I always do it. Sometimes I'm not always so like optimistic about it, but I do think it's working. So keep doing those things.
Yeah, thank you. Well, thank you so much to Joe and Jenny and Jess for providing all your great insights and all your great work. This has been a fantastic conversation, and thanks so much to our audience for sticking with us until the end. And have a good afternoon.